as Jennifer said, both the SCR clearance with all the addresses and then service can become actually two of the more difficult and time-consuming parts of these cases. Understandably, the courts are very concerned about due process and ensuring that parents have adequate notice of the guardianship proceedings, the custody proceedings, and also the motion for special findings. And so in every case, the parents will need to be served with the summons and the petition, and with all other family court papers. In custody cases, personal service is really the gold standard and generally required. It's often possible to find someone in another country who can effectuate personal service on respondent parents. Can fill out an affidavit of service in their native language, which can later be translated, can have that notarized. In many places, the notaries will actually photocopy the ID of the person who's signing the papers, which is even better. Just an extra layer of proof to the court that the person who is signing is in fact the person who is the parent, or at least who's named on the birth certificate. The CPLR governs, so you should definitely look at the CPLR. In cases where you cannot personally serve a parent, an affidavit of diligent efforts is required, where you explain all the efforts you made to find the parent. Certainly in a case where a child has been abandoned by someone, perhaps even abandoned prior to their birth or shortly after their birth, it may be impossible to locate, but in that case, you just need to show your due diligence. Internet searches, perhaps even a letter. If you believe the person's in the US, internet searches are far more useful, phone calls and letters to other known relatives, and then courts have the discretion to order whatever service they believe is proper. So it could be mail service to perhaps a grandmother or to another relative. Much more common in guardianship cases, there's a possibility to obtain a consent and a waiver of service. There's actually a very specific form for this on the website, in the family court website. And again, those will be notarized, witnessed, or notarized, and the original will be provided to the court. In guardianship cases, only in guardianship cases, there's a specific provision in the Surrogate Court Procedure Act, which states that a parent who has abandoned the child actually is not entitled to service. So it does allow courts in guardianship cases where the child has been abandoned, and often you will have to have an inquest on that very specific issue in order to have service waived. Courts may waive service. And the alternative, they may simply, issue or order an alternate form of service, such as mail by DHL, in very, very infrequent cases, publication. That's something that's never been ordered in any of my cases, and I hope it is not in yours either. But again, as Lenny mentioned, that the costs can be really high. With international DHL, it can be $80. If you do it several times, it can really, it can be a significant expense for a family, and for your office, of course, as well. You must provide the court with proof of service before the petition and the CIDS motion will be heard. I failed to mention when we were talking about abandonment that a question that frequently comes up is whether a child who's been abandoned before their birth or shortly after their birth, someone who never knew their mother or father, qualifies as abandoned. There was a case that talked about the need to unify before you can find that reunification is not viable. That case really went against a long history of family court case law and procedure where in many other contexts, including the foster care context, reunification is found to be not viable frequently when a child has never met that parent. So recently the appellate division has very clearly stated that that's not the case. In Currency, they found that the child was in fact not able to be reunified with her father due to abandonment when she had been abandoned at birth. So something to keep in mind. Also in guardianship, there are these very specific procedures. Fingerprinting is another thing that can really raise a lot of issues. It is not statutorily required that all members of a petitioner's household be fingerprinted, but it is something that has developed as a as a practice in almost every family court. And in fact, many judges believe that it is required by statute. So they will almost definitely order fingerprints on all members of the petitioner's household. If the child is living with the petitioner, that's definitely true. If the child's not living with the petitioner, it may not be true. They may order fingerprints in both households, both the child's household and the petitioner's household. So of course, when you're working with undocumented individuals, this is very frightening. The fingerprints, at least in the 5 boroughs, can be done in the family court, which I think, though they are meeting armed security officers, it's very different than in some of the outer boroughs where you do have to often get printed actually at a police station. But in any event, these are not linked to immigration. These are criminal background checks. They are sent to the New York State division that actually they issue the fingerprint and the criminal history results directly to the court. And we've never, encountered a situation where anyone has had a problem despite their undocumented status with this fingerprinting. But understandably, it's very, very frightening for many, many people who are just loath to go into family court or any other place filled with police officers. So if a guardian has a criminal history, that's not an automatic bar to guardianship. The standard is totality of the circumstances. So it really is a matter of looking at what the crime is, how long ago it occurred. Even cases where perhaps the guardian has, some pretty serious crimes in the past, if they can show rehabilitation, if the child can testify that they feel safe, if it can be shown through the court-ordered investigation that in fact the home is safe, it doesn't necessarily have to be a problem.